Hi guys, welcome to my channel. I hope you are all well. Today we will learn about intellectual property rights in professional practices. The table of content is introduction, confidential information, patents, copyrights, acts permitted in relation to copyright, remedies for breach of copyright, plagiarism. Introduction. Intellectual property rights are often the most valuable asset owned, used, and developed by software houses. Intellectual property rights include confidential information, patents, trademarks, design, copyrights protecting computer programs. They protect information stored by electronic means and all of paperwork which accompanies a program, such as user manual plus any multimedia packages and most items on the web. Great care should be taken to protect, exploit, and enforce intellectual property. The name under which product is sold may be registered as a trademark. Next, what is patent? The hardware or a process used in its manufacture may be protected by a patent. Next are designs registry. The look of the product may be registered in the design registry. Copyright. What is copyright? Software can be protected by copyright. The know-how which goes into developed of product may be protected as confidential information. It's called confidential information. What is confidential information? Unauthorized use of intellectual property can be stopped by injunction, and damage may be sought for infringement of those rights. The law is constantly changing with technological advance. General agreement on tariffs and trade get concerned the protection of intellectual property rights in the face of widespread piracy of software products. Next are confidential information. What is confidential information? Information which is not public property and public knowledge. Any category of information from personal confidences to trade secret and sensitive government information, and or all of which a computer scientist might handle in the course of his or her work, or all or any of which a firm may want to protect against unauthorized use or disclosure by others. Information will be protected only if it is confidential. Non-confidential information used as protected unless protected. Example, by copyright or patent is deemed to be in the public domain and can be used by anyone. Three conditions must be satisfied before an action for breach of confidentiality can succeed. The information must be confidential. The information must have been disclosed in circumstances which give rise to an obligation of confidence. There must be an actual or anticipated unauthorized use or disclosure of the information. Next topic are patent. What is patent? A government authority conferring a right or title for a set period, especially the sole right to exclude others from making, using, or selling an invention. A patent gives to an inventor a monopoly in an invention. This means that the inventor is given the exclusive right to use or exploit the invention for a defined period. The monopoly granted by patent law is so strong that the owner of patent may even exclude independent inventors from the market. The better the patent and the more commercially desirable the breakthrough, the more likely it is to be challenged. For example, if competitors can produce a similar product or process which not covered by the patent, they will be free to market it and to erode the commercial advantage of the patentee if they can prove that the subject matter of the patent has been used or disclosed before they can invalidate the patent. Patent Act merely set out a number of criteria which must be satisfied before an invention can be patented. A patent may only be granted if the invention is new. Number 1. Number 2. It involves an inventive step. Number 3. It is capable of industrial application. Number 4. The subject matter of the invention does not fall within an excluded class. It is possible to patent something which is more than just a program, something which can be called for simplicity a program plus. A computer program is not excluded from potentiality patentability if it produced or is capable of producing a further technical effect beyond the normal physical interaction between software and hardware. It's potentially patent patentable if it makes something else do something.